Terminating an offer. The final issue for you to consider in the context of offer and acceptance are the circumstances in which an offer can be withdrawn. Fortunately, this is very straightforward. The general principle is that an offer can be withdrawn at any point before acceptance, and that termination is effective once it is communicated to the other party. Surprisingly, perhaps, case law indicates that an offer can be withdrawn at any point before acceptance, even where the offeror has indicated that they will keep the offer open for a period of time and then decides to close the offer sooner. For example, if I say that you have 6 weeks to decide, I could say after 2 weeks that I am withdrawing the offer. The authority for this, Payne and Cave and Routledge and Grant. This seems like it could be a little unfair, particularly where the other party has relied on having 6 weeks to consider the offer. Perhaps he has undertaken some other activities on the basis of having 6 weeks to accept, and he would be out of pocket if the offer were revoked before the 6 weeks were up. Although the law of contract indicates that the offer can be validly revoked at that time, perhaps the law of promissory estoppel, which I will consider in another podcast, might step in, with equity seeking to prevent reliance on strict legal rights, mitigating the harshness of the common law, requiring the offeror to compensate the other party for his costs which he incurred in reliance on the 6-week period if he is to be allowed to withdraw the offer. Similarly, laws of fairness of advertising may also take a dim view of conduct of this nature. To be a valid revocation, it must be communicated to the other party. Unlike the rule of acceptance, communication of a revocation by post takes place when the revocation arrives, not when it is posted. The postal rule does not apply. This is consistent with the thinking behind the postal rule. In the case of acceptance, the offeror has agreed to accept communication by post and so is expecting them. In the case of revocation, the other party may have no reason to suspect that a revocation is coming, and thus treating the notice as effective once it enters the postal system, rather than once it is delivered, would be unfair.